rules of ethics. We'll start moving a little quicker here. This is 8.01-271.1. So essentially, the first paragraph says, any and every pleading that you file as a lawyer, you have to sign your name on it, and it lists some requirements as to what all you have to include other than your name. Talked about 3 certifications earlier. So when you as a lawyer sign a pleading, you are saying to the court, you've read the pleading, motion, or other paper. So don't sign stuff you haven't read. Number 2, you're also saying the best of your knowledge, information, and belief that you have done after a reasonable inquiry that is well-grounded in fact and warranted by existing law, or a good faith argument for extension, modification, or reversal of existing law. So you're certifying you've done your homework, you've looked into the facts, you believe these are good facts, and you believe that a good faith basis in law or an extension of law or a reversal of the law supports your case. 3 is most important. You're certifying that you are not trying to harass the other side. You're not imposing it for an improper purpose, to harass, to cause unnecessary delay, or a needless increase in the cost. If you don't sign it, the court's going to strike it. So you kind of have to sign your pleadings. This paragraph deals with oral motions. So if you are making an oral statement in court or an oral argument, you are in essence adopting the same certifications from the preceding paragraph to your oral statements in court. Finally, if a pleading motion or other paper is signed or made in violation of this rule, the court, upon motion or sua sponte, shall impose upon the person who signed the paper sanctions. This is not a may impose. This is a shall impose. So if you bring this up to the court and you can prove that they violated Romanette's I, double I, or triple I, the court is supposed to sanction them. It doesn't say what they have to sanction them with. It could be a stern talking to, but it says shall be sanctioned. So that is an important wrinkle. Okay. Here's where we actually get into the reads of, well, tell me about this good faith standard. And so one of the first cases I came across in researching this is Telogen versus the Board of Supervisors. And in this case, there was a dispute over moving the county administrative offices. And the lawyer asserted that the offices were part of the county seat and courthouse, and then essentially tried to force an election on the issue. The trial court sanctioned him and said that your conduct or that your argument was not supported by existing law. So he appeals, goes up to the Supreme Court, and the Supreme Court went and looked at the applicable statutes that had defined a county seat or defined the administrative offices as being part of the courthouse or the county seat. It then went on to say, to cite 2 published cases saying, hey, these interpretations of this law have been adopted. Therefore, the attorney could rely on these cases in making this argument. The signature was fine, reverse sanctions. And please note, it reversed the sanctions after the lawyer's demurrer was sustained. So this guy filed a cause of action, it got demurred, he got sanctioned, sanctions were reversed. Because, and keep in mind, a demurrer or 12b6 motion, if you're into federal practice, or a motion to strike in defense practice, says you failed to make a prima facie case. You pled something that wasn't wrong. Can't get sanctioned. Like, this guy had a good faith basis in argument, therefore the sanctions were reversed. And we all know what it takes to prompt a reversal, so this is a fairly big deal. Perhaps it also implies that demurrer wasn't argued well enough, but that wasn't dealt with in the case. So, Gilmore versus Finn. This is back when we had Governor Gilmore. And what Governor Gilmore did, and there was a similar case in Florida, the Terry Chavo case, where it made the news, but the governor filed a petition to stop a defendant from withdrawing life support from someone who'd been in an automobile accident. In this case, the governor asserted that the injured person was not in a persistent vegetative state as was defined by the Virginia Code at the time. And that issue was litigated in the underlying trial, and it went up to the Supremes very quickly. They unanimously rejected Governor Gilmore's interpretation, sent it back down, and the trial court sanctioned him for taking that position. However, Gilmore versus Finn provides an insight as to how courts are supposed to evaluate whether or not to sanction an attorney. So it said, the statute 8.01-271.1 does not require the court to decide if the challenge pleading was warranted by existing law. I mean, I don't think that's that controversial in the assertion. It's warranted by existing law or a good faith argument for the extension, modification, or reversal. So it requires the court to decide if the party filing a pleading could have formed a reasonable belief that their position was warranted by a good faith argument for extending, modifying, or reversing the law at the time of the filing of the pleading. In this case said that at the time of the filing, the Supreme Court had not yet made its unanimous ruling on whether or not the facts met the definition of persistent vegetative state. Therefore, the governor advanced a novel legal theory, and he could have reasonably done that applying the case law and the statute. So this case seems to give an attorney fairly broad leeway in bringing novel legal arguments or causes and claims for the court, as well it should. However, I'm going to add the wrinkle here, because there's always a wrinkle. This case treated the governor as a unique party. It cited a statute that mentioned a statutory duty of the governor to protect Virginians and act when he felt it was necessary. So in other words, the court said not only was he advancing a novel legal theory, but he was required to step in and advance that novel legal theory. It's impossible to tell how much the duty of the governor to act influences this opinion, but this opinion is fairly broad and is fairly forgiving in terms of what a good faith standard is. So in essence, if you can back up your legal argument, if it's a novel legal argument and you can logically and rationally stake out your position, Gilmore says you should be okay. So this is Williams and Connolly versus PETA. And this case involved, and the opinion is 20 or 30 pages long. It involved complex civil litigation. There were 2 or 3 different cases and causes of action going on against Williams and Connolly and PETA. And in essence, Williams and Connolly lawyers filed a motion opposing a show cause. And then they went a step further and accused the judge of unethical conduct. So what they alleged is that the judge had a bench conference in an attached proceeding and not let them know of the bench conference. The Supreme Court, and then of course Williams and Connolly lawyers were sanctioned at trial for falsely accusing the judge of unethical conduct. Williams and Connolly appeals because no one wants to be sanctioned. And they took it up to the Supremes. And the Supreme Court went through 5 essential facts in their pleading one by one, and they said that 3 of them just weren't accurate. They went a step further and said that they speculated a 4th critical fact in their petition. So if you go back to the you have a duty to reasonably inquire as to whether or not your pleading is well-grounded in fact, they speculated, therefore they failed to meet that basis. They speculated without any basis in fact. The timing of the bench conference provided a factual basis in support of the motions. They also found that Williams and Connolly's lawyers' argument that Rules 112 and 415 applied to a judge did not sound in good faith. And 112 has to do with service of pleadings on another party, and Rule 415 has to do with motions and how those are disputed. Further, it tears apart their sanctions motion even more. We can wait about 12 minutes before let's go, right? You'd let me know if I was that boring. It further held that their arguments about the judicial canon were not made in good faith, no objective reading of the law, or an extension or modification thereof supported their argument. Here's the big worth in this opinion, though. The Supreme Court held the circuit court's determination that the contemptuous language of Williams and Connolly's lawyers' motions inferred an improper purpose. Their motion to recuse used language that the circuit court deemed derisive in character. It said contemptuous language and distorted representations in a pleading never serve a proper purpose and inherently render that pleading as one that is imposed for an improper purpose within the meaning of Clause 3. Such language and representations are wholly gratuitous and serve only to deride the court in an apparent effort to provoke a desired response. So, in other words, even though that rule said you should be polite and courteous to counsel, if you are derisive in character, contemptuous, and make distorted representations in a pleading, and they file for sanctions, you're going to get sanctioned. This case allows a court to make an inference as to an improper purpose if you're filing venom and nothing but venom at the other side. So we've already discussed canvas briefly. Not really going to hit it again because I think we only have 15 minutes left. Okay, Oxenham versus Johnson. This has to do with the filing of a malicious prosecution. And what Oxenham did is he filed the malicious prosecution action against the person named on the warrant. Person named on the warrant, lawyered up. We'll call them, I forget the name of the agent actually, but we'll call them Agent Johnson. He files on Agent Johnson. Agent Johnson lawyers up, scares up 3 witnesses, and then they let Oxenham know, hey, look, these 3 people said, our gal didn't do it, Johnson didn't do it, they just put Johnson's name on the warrant because she was the last person in the office. They warned Oxenham before the trial that Johnson had nothing to do with with the arrest warrant's issuance. And so the trial court sanctions Oxenham and says, look, you persevered after the warning, so that implies that you filed this suit with the intent to harass. Supreme Court says no dice, surprisingly. Surprisingly to Johnson's lawyers anyways. The court stresses the timing of the duty. So, in other words, Johnson appeared on the arrest warrant. Oxenham can use the arrest warrant, use that signature on the arrest warrant to form a good faith basis in fact for asserting, yes, Johnson, you falsely accused, or you initiated the malicious prosecution. Furthermore, some people may say, well, hold the phone. You've been warned that 3 witnesses are going to testify against you. Doesn't that change your mind? And the court says no, absolutely not. Because the court continues, indeed, the jury may not have believed any of the 3 witnesses who, in contradiction to the language on the arrest warrant, denied Johnson's role in instituting the interference charge against Montecalvo. Juries are not required to accept testimony which is contradicted by credible documentary or circumstantial evidence. Therefore, the warning had no effect whatsoever on this case. The court did say that the duty in this case to investigate the facts behind your pleading applies before you file any new pleading or motion or other paper. So long as Oxenham was continuing to investigate the facts, even though I had the witnesses before he filed his new motions, he was okay, and they let him off the hook for sanctions. Now, I'm going to tell you, it was a 4-3 case, and there is a dissent that cited the warning. And it also ties into LEO 1224's duty to investigate. So it was a close decision. Ultimately, I think it's the right decision to make because juries can and do disregard witnesses all the time. Okay. It's 10 till 4. I can keep chugging through cases or I can deal with hypotheticals, and I'm going to leave the choice to you. How many people want me to skip the hypotheticals? How many people want the case law? Okay. We're going through the discovery rule right now. I will point out very briefly, since it comes up in the hypothetical, the Allied Concrete Company versus Lester case. How many people have heard of this case, the Facebook case? Clean up your Facebook page. No takers? Largest wrongful death award, I think, in Virginia's history ever came out of this case. The lawyer also got this barred. Essentially what happened is the lawyer told his client, hey, clean up your Facebook page. and the client did. They found out about it later in discovery. Allied Concrete Company did. The court imposed sanctions of $542,000. Let that sink in for a minute. $542,000 was imposed. Just in sanctions. Now, they let the plaintiff keep the verdict, but most of that fee was also paid by the attorney. And then he got disbarred for 5 years. So this is the published version. This has probably 4 or 5 different sub-opinions if you actually look at it in Lexis. The published version in the Supreme Court did not directly deal with the spoliation issue. However, one of the unpublished ones did. And for those of you who've tried to ever get anything out of Facebook, you send them the subpoena, they send you the push-off letter. It probably did cost them every penny of $542,000 to go out to California and make Facebook cough up the evidence. So don't destroy the evidence. Okay, hypothetical number 1. You have agreed to represent a college student in a felony marijuana distribution case. After speaking to the student, you believe you have a strong case. There's always a catch, isn't there? Much to your chagrin, you subsequently discover that your genius client posted numerous photographs in his Pinterest account, which the public can view, of him at parties in his Party Rockers thread. The photographs depict him distributing and accepting money for a green, ground-up, leafy material packaged in glassine baggies. The photographs also depict that green plant material being rolled into small pieces of paper, ignited, and subsequently inhaled by other nearby partygoers. Several of the photographs are time-stamped with the date and time of the offense in the indictment. In these photographs, your client wears a shirt with a marijuana leaf emblazoned on it that says, "Legalize this," and depicts an image of a cannabis plant. The client also has a LinkedIn account where he lists his job as a purveyor of the finest pot. Sadly, your client goes to school in Virginia and not Colorado. So questions. Number 1, can you tell your client to delete the photos on his Pinterest account? Any takers? Obviously, you cannot tell him to delete them. Secondly, can you have your client deactivate the Pinterest account? What about terminating the account or restricting access? Now, we'll get to that in a minute. And 3, can you tell your client to remove his job from his LinkedIn account? And 4, what can you tell your client to do regarding his social media accounts? Okay, so question number 1, we all got the right answer. It's pretty clear you can't tell him to delete the photos. He's kind of out of luck on that one. 3.48 governs, you can't obstruct another party's access to evidence, you can't alter it, delete it, or destroy it. Fairly straightforward. How many people here think the photographs are probably relevant evidence? Everyone in the room should put their hand up. Allied Concrete Company versus Lester comes up, tells you what happens if you destroy evidence. So counseling a client to delete the photo violates Rule 3.4 if Pinterest does not keep a copy of the information associated with the pinned photo. Now, question 2, can you tell him to deactivate or terminate his Pinterest account? And if you swap Facebook with Pinterest, you get into a little bit more of a meaty discussion here. And also, keep in mind, this is a criminal fact pattern, not a civil one. So there is room for argument. But deactivating an account in Pinterest has the same effect as deleting a Facebook account, which means it makes the account no longer searchable to others. If you tell him to deactivate the account, you've restricted access to a Pinterest profile. Now, if you tell him to set a privacy setting, such as making a board where he put his photos on a secret board, or putting more privacy on Facebook or restricting your LinkedIn's publication, it doesn't destroy any information. Now, how many people think you can deactivate a Pinterest account so long as the information stands? Does that obstruct another party's access to evidence is the question. Any takers? Do you think it's permissible or not? Okay. Okay. I also share your opinion both in the criminal and the civil context. Here's why. In the civil context, if you have deactivated an account as opposed to deleting or destroying it, you haven't actually altered the other side's access to it. They can hit you with a request for production of documents in a civil case. In a criminal case, law enforcement has broad subpoena power. So whereas in a civil case, if you hit Facebook with a subpoena ducis tecum, as I have done, you'll basically get a go-away letter. The Stored Communications Act applies. We're not giving you anything. On the criminal side of things, it's a little bit different. There is a law enforcement subpoena that Facebook and many of the other social media accounts work very well with. So there's the criminal side can get at that information. You got a question? Absolutely. Yeah, before you tell your client to do anything with social media, you have to make that inquiry. Because we know that if you deactivate an account on Facebook, it's still all up on Facebook. And notice I'm saying deactivate. If you delete the account, you can't find that information after 2 weeks. They'll tell you it's somewhere on their servers, but there's no way you can, it's no longer indexed, and there's no way they can find it. Now, LinkedIn, on the other hand, if I'm remembering this hypothetical right, now, at the time I wrote this, I said it's criminal case and not civil. It may make a difference given the quantum of information necessary to get a subpoena ducis tecum in a criminal versus a civil case. And criminal has very truncated discovery rules. But if you know what their account is, then the police can get at it, and often do. Terminating the account, don't do it. If you delete the account, you've destroyed the evidence. Now, and this is because Pinterest, Facebook, and all of them keep information on their servers, but what I found out after I drafted this hypothetical, of course, the information's always there. What happens is they remove the indexing protocol after 2 weeks, and it becomes impossible to find. So in essence, it's gone. If your client, yeah. So basically, if your guy terminates the Pinterest account, it's going to disappear into their servers. You've destroyed or obstructed access, which is a bad thing. Now, so 3, can you do it with his LinkedIn? And this relates to your question directly. Depends on the facts of a pending request for information from LinkedIn. Now, of course, I found out after the request, LinkedIn retains customer data for 30 days after the closing of an account. Now, I want to say after the deactivation. Okay, after the deactivation of an account too. That's why you have to investigate what do they do with their data before you advise your client one way or the other. And that was a very good question because Facebook and Pinterest keep a deactivated account. LinkedIn doesn't. So you probably can't tell them to take the job down, is I guess what I'm getting at. Was there another question? Chris was, oh, yes, sorry. Would really depend on the stage of the case at the time. So, and this is why you should write down what you advise your clients, because if you have advised them, don't do this, and they do it anyways, if they do get sanctioned, the sanction would be directed at them as opposed to you. And you see that differentiation in Allied Concrete. I would say about 3/4 of the sanction was directed at the attorney. Like the attorney themselves, you have to disclose this money versus the client. I mean, if you're now, does it trip into the duty to disclose fraud on a court is also a factual intensive determination. You're not you can't destroy evidence. Whether or not it's a fraud depends on what the question is asked. If they ask, if the Commonwealth got it off of Pinterest before he deleted it, they say, oh, do you have a Pinterest account? And he says, well, no. Did you have one? No. Then you have to disclose. And if he fails to authenticate whatever they ripped off, like pulled offline beforehand, then you have to correct that. I do not know at 4 o'clock on a Friday, standing on my feet, whether or not you would have to do anything else. What I do know is that the ethics hotline is more than happy to answer your questions. It's actually, I had a call into the ethics hotline before I came here, which is why I missed the first hour after lunch. So that's what you do if you can't research the answer off the top of your head, but it really does depend on the status of the case. If they destroy it after discovery is issued, I think you may have to tell the other side, my client destroyed this. But I hope that was helpful. Any other questions? Speaking of which, do you want me to go through the rest of the hypothetical, or? Okay. Huh? Sure. So in terms of LinkedIn, the second question was, can you restrict access to the account? LinkedIn has a 2-tiered access system. So a public profile has something everybody can see. Private profile, obviously you have a little bit more. So for example, I sent a LinkedIn request to Rachel back there a couple of days ago, got the acceptance. Her public profile is it has her job and that's about it. Like my public profile, the private profile, you can see their picture, you can see where they went to school. So there are 2 systems of access. So making the account non-public probably doesn't actually alter a party's ability to access that evidence via subpoena to LinkedIn or discovery request to the other party. I'm going to couch this by saying you can send a subpoena to LinkedIn. They're probably going to give you the same amount of pushback as Facebook. They're going to make you litigate it. So your request for production of documents is your gold standard there. And if LinkedIn does not keep the information so it may be accessed by subpoena, you can't delete the information from you can't remove the job from your client's account. And since we know that jobs are in the public profile, your public profile probably doesn't actually help that particular fact very much, although it might limit access to whatever other stupid pictures he put on there. Okay. Question number 4, what can you advise your client to do? I'll tell you what what I would tell this hypothetical client to do. I would tell him you cannot destroy the evidence. You cannot hide the evidence. But you should not make new evidence. So in other words, you can't destroy what you haven't made. Don't make new evidence. Stop posting on social media. Don't respond. Don't post. Take a vacation. You should be able to tell your client to deactivate the accounts or make them not accessible by the public, assuming you've done your investigation to the social media outlet and that they will retain a full copy of the account on the server. As long as someone can get at it by subpoena, I think you're okay, be that law enforcement subpoena or otherwise. You may not be able to tell your client to delete the job post. If doing so will remove that data from the servers of LinkedIn or Pinterest, as that would be destroying the evidence. Finally, you should not be able to tell your client to terminate the accounts, because if you terminate your account, either at Facebook it's 2 weeks, LinkedIn is 30 days, that stuff's going to be gone. So, and it's 4:10, so I think that's it. Have a good weekend. Any other questions, comments?